Hafide, good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA25-012, People of Guam Plaintiff Appellee v. DJ Tosiuo, aka DJ Peter Robert Tosiuo, aka David Peter Robert Tosiuo, aka DJ R. Tosiuo, aka DJ BJ Saki Prick from Barragata, defendant appellant. Appearing for defendant appellant is attorney Terry E. Timblin. Appearing for plaintiff appellee is attorney G. Ray Kolb. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Timblin reserves 5 minutes.
Mr. Timblin, you may proceed.
Chief Justice Torres, may it please the court, Mr. Kolb. We now have, it started out as one issue, now it's turned into two. First, with which definition of firearm applies in this case. Second is how far, if at all, the government must go to conclusively prove its case beyond a reasonable doubt. As to the first issue, I believe it is important to distinguish between malum in se and malum prohibita. Malum in se are acts that society regards as inherently evil: murder, rape, robbery, assault, theft, all bad. Malum prohibita are acts that are not inherently evil but are outlawed for the purpose of enforcing a regulatory scheme. Title 9 of the Guam Code Annotated deals with malum in se. Title 10 deals with malum prohibita. It is true that the Title 10 does include criminal penalties for these, but these are still in place to enforce, again, a regulatory scheme and not simply to punish. Chapter 60 of Title 10 deals with the regulation of firearms. Mr. Tosiuo has been prosecuted for violating Title 10 and not Title 9. The ownership of a firearm, again, is not inherently evil, but the government has the right, at least for now, to decide who may own one and who actually does own one, know who owns one. In order to regulate firearms, the term firearm must be defined. And as to Title 10, it is a pistol or revolver designed to be fired with one hand, with a barrel less than 12 inches in length and capable of discharging loaded ammunition or any noxious gas. I submit that the legislature chose to define firearms differently. The fact that the legislature chose to define firearms differently in Title 9 simply has no bearing on this case. As to the second issue, I offer a quote from Wigmore on Evidence, section 1150. If, for example, it is desired to ascertain whether the accused has lost his right hand and wears an iron hook in place of it, one source of belief on the subject would be the testimony of a witness who had seen the arm. In believing this testimonial evidence, there is an inference from the human assertion to the fact asserted. A second source of belief would be the mark left on some substance grasped or carried by the accused. In believing this circumstantial evidence, there is an inference from the circumstance to the thing producing it. A third source of belief remains, namely, the inspection by the tribunal of the accused's arm. The source differs from the other two in omitting any step of conscious inference or reasoning, and in proceeding by direct self-perception or autopsy. In other words, testimonial evidence as to an item is all very well. Circumstantial evidence as to an item is all very well, but there is nothing quite like actually examining the item itself. If you want to know what the temperature is outside, you can ask for an opinion, or you can use a thermometer. If you want to know how fast a pitch is, you can ask for an opinion, or you can use a radar gun. And if you want to know whether a firearm with a broken mainspring can be made to fire with a new mainspring, you can ask for an opinion, or you can replace the mainspring.
But why wasn't the opinion sufficient evidence to show that it met the definition of a firearm, which meant that after repair, it was capable of being fired?
Again, it's, yes, that's probably, well, I guess the question is how, if anything, you court wishes to impose on the government to avail itself of all available information in bringing a charge. Yes, I guess that's, the opinion is admissible evidence. My point simply is that when it's not particularly difficult or burdensome to go the last few feet as opposed to the last mile, that maybe they should be required to do it. Again, that's that's something that the court would have to decide for itself, but it's kind of a sliding scale. At some point, it's too much trouble, or it's almost impossible. But in this case, it said the mainspring was broken. If we had a new mainspring, it'd work. Why not get a new mainspring? That's something that the court, I think, has the power to require. That again, it would be on a case-by-case basis, and again, it's the court can decide whether that was just too much trouble or not.
Well, the government argues, and I thought you were going to continue to advance that we should revisit and reverse People versus Tennyson. In that case, we clarified that a firearm is determined by its design and apparent capability to discharge projectiles, and not by proof of its current working condition, which you are now arguing. And you didn't cite any case law for us to consider why the Tennyson's interpretation of the firearm statute that's at issue here should be revisited. And also your statutory analysis, I don't quite follow in terms of the tools of statutory interpretation that we traditionally apply. So can you kind of clarify that for me in terms of, you addressed it briefly in your brief?
Well, I'm not asking Tennyson to be revisited at all. I'm just simply pointing out that you're dealing with two different types of prohibitions, or one is evil and one is just regulatory. Secondly, that if the government, if the legislature decides to regulate firearms, that's a separate issue altogether. And in this case, they chose to define firearms differently than in Title IX, and in the Tennyson case, which was again a theft of a weapon rather than simply possessing the weapon. Again, it's a question of legislative intent.
But what support do you have that we should read Tennyson so narrowly, when that doesn't seem to, the case doesn't seem to suggest that that was the approach that was taken
Well, basically
by the
because,
legislature?
I'm sorry.
I'm sorry. Go ahead.
Basically because the issue was not raised in Tennyson. Tennyson was again a Title IX case, theft of a gun, and Title IX defines it as again something that looks like a gun that appears to be something that would work, and et cetera. Fine, I'm not arguing about that. I'm just saying we're dealing with an entirely separate statutory scheme, and I think we have to follow what the legislature provided in that particular statutory scheme.
And you're arguing that the definition of a firearm should be different for each statutory scheme?
Correct.
And here, because we're talking about possession of a firearm and a firearm being unregistered, that would be different than use of a firearm, even if it was inoperable in a holdup at a store.
Well, again,
I mean, let's say you had a firearm at a robbery of a store, armed robbery, that was incapable of being fired because it had a broken mainspring. Are you suggesting that he should not be charged with armed robbery because the gun didn't work? Or that should be different, and we look at each case for purposes of determining what constitutes a firearm?
of course, in armed robbery, basically all they got to show.
Can you
is
raise
something.
your microphone, Mr. Timlin? Can you raise your microphone?
Just lift it up a little,
Okay,
yeah.
Sorry. Well, first of all, in a robbery case, all they have to show is that he had something that looked like a gun. If he has an airsoft BB gun, doesn't matter. It looked like a gun. It scared people into giving him money.
Right.
So that's an easy one. So I'm not arguing anything any different about that.
Okay. But for an unregistered firearm or possession of a firearm without a firearm ID, you say it has to be proven that the gun is operable.
Yes, but there's of course many ways to show that, like if it was fired, for instance, something like that. If the gun wasn't recovered, I mean, I'm not saying that it's the government has to absolutely come up with the gun and show that it goes bang.
So for a felon to avoid possession of a firearm without a firearm identification card, all he has to do is take out the mainspring, keep it on the side, and then he won't be in possession of a firearm without a firearm ID.
Well, if that's how the legislature defines it, then yes, again, we're talking about Title 10, separate statutory provision, and
But what can you point to in Title 10 that where the legislatures that express that or implied that we should read the firearm differently in Title 9 and Title 10? The definition.
because the legislature itself it draws a difference. They chose at some point they could have said anywhere in the whole code, for purposes of anything in this code, firearm means this, but it didn't. That's pretty much all I can say. This case does bring up I can remember, I don't know how far back your honors go, but there was a case years ago where there was an issue of operability of a handgun in the middle of a trial. And so it was a very simple solution to the thing. The judge and everybody else walked outside the courthouse, had somebody point the gun into the barrel where they clear, where the police clear the gun, pull the trigger, and it went click, not bang, and the case was over. Again, I'm not sure if that was a possession charge or armed robbery charge, but I know that the case was dismissed immediately. But I guess probably beside the point. But anyway, I said they looked to legislative intent. They had chosen to treat guns one way in one set of statutes, another way another set of statutes. So again, it's just simply a matter of, again, case by case, sliding scale of how far do you have to go? If you want to settle for not the best possible evidence, I guess you can. And suggesting that maybe there should be a due diligence requirement at some point.
All right.
That's all I have. If any questions?
Thank you, Mr. Timblin. Mr. Cope?
Thank you, Your Honor. Mr. Tim. Going right to his argument about the different titles. This thing is going off. in Tennyson, the argument is that because it was in Title IX, Chapter 42, I think. Okay. Apologize for that. Is that somehow it doesn't apply when the two charges this time are both in Title 10, registration and an ID card, and the definition that this court described in Tennyson is in Title 10, Chapter 60, entitled Firearms. I don't see how that can't be more close than it needs to be. I understand his argument about the Title 9, Title 10, but this court's already ruled on that in Tennyson that you go by that definition in Title 10. So I think that's kind of the core of the argument. To be honest with you, I don't know how it doesn't apply here in this situation, particularly because everything's under Title 10, Chapter 60, entitled Firearms. So, and since the charges are just registration and ID card, there's no need of whether it fires or not. And of course, I would go back to the evidence in the case is that the expert James Iverson, or Iverson perhaps, that was not accepted by everyone without objection. He testified that the Smith & Wesson .357 Magnum revolver recovered from Tosiuo's vehicle was a real firearm. And he went and described what that was. It was designed to fire a projectile by means of explosive force. And that, and as this court said in Tennyson very specifically, prosecution wasn't required to prove that it was operative or not. And if you go down that, if to require proof that a gun can fire today would mean a firearm ceases to be a firearm the moment it jams or like a firing pin, the chaos that would entail seems to be pretty big. I mean, it contradicts Tennyson. It undermines legislative intent, I believe, which is all in Title 10, Chapter 60. So I don't think that argument particularly applies, particularly in this case here.
Well, what was the legislative intent? What was the purpose that, or the concern that the legislature was expressing
Well,
when it?
Your Honor, it seems to me that Title 10 was about proper notification, proper identification, making sure just the registering and the control of gun ownership, which I think is important. And it doesn't really seem to, whether a gun works or not, doesn't really seem to matter as far as ownership and proper identification, because you shouldn't have one, whether it works or not, if you're not properly registered. I kind of cut my argument right to the core. That was the last thing I was going to address, but since we got into it, any other questions the court may have, I will be happy to address if I can.
I don't have any questions, Mr. Cobb. Thank you. Mr. Timblin?
Couple things. One is that again, I think it emphasized that the issue I raised today was not raised in Tennyson. I'm not arguing that Tennyson should be overruled. Also, again, I fail to see why anybody, the chances of this happening where somebody is going to go rob a store, why anybody would think that far ahead that, well, gee, if I rob a store and this gun actually works, trouble, so I'll just take the firearm out. If he's going to have a real gun, they're going to use a real gun. And I think it's highly unlikely that they will, again, that the average person who robs mom and pop stores and gas stations is going to think that far ahead.
But when I look at the definition in Title 10 on a pistol, for example, it means a firearm of any shape, whatever, and designed to be fired with one hand with a barrel less than 12 inches in length and capable of discharging loaded ammunition or any noxious gas. So if the firearm is designed in a particular way, which this was designed to be fired, does that definition encompass it?
Well, again, it's the last.
It's capable of being fired based on the testimony of Averman if they added the mainspring to it. that was his testimony, right or wrong. I mean, you probably could have put contradictory testimony that says, no, even putting a mainspring would not have made that capable of being fired.
Well, again, it's that last sentence, capable, not just looks like it capable, but says capable, period. So again, I think that is, that's the crucial point. Again, he gave an opinion, the firearm expert, and that was accepted, but still, that's what it says, capable, and whether that was enough when it could have just been verified. Again, I think it's, as I pointed out in my brief, I think that whether they put the mainspring in and tried to fire the gun, whether it fired or didn't fire, justice would have been done. That wouldn't even be here today. So that's all I can say.
All right.
But just one, but were you able to find any case law to support? Were you able to find any case law to support the argument that you're making today?
I can't say that I have. This would be kind of a unique thing and chance for this court to make some new law on the subject. I don't have any case law.
I'm kind of hesitant to do that if we're just going to go out there on the limb and be the only one to have this unique approach to defining or interpreting possession of a firearm, that it has to be operable when the legislature hasn't clearly expressed that was his intent, that whether the firearm is operable or not doesn't make any difference or makes a difference. And without any case law to support such an approach, that's a difficult sell for me personally.
Well, I guess my argument is actually it goes beyond just firearms. Again, I think at any time when there's I can't think of an example, but there could be other possibilities where, again, it would have been a simple matter of do this or that, spend 5 minutes looking at it or whatever, and but then they didn't do it. So it's not necessarily applies to just firearms, but again, it's a judgment call for this court.
Yeah, but you got to give us more. I mean, I got to give me more in terms of applying say, even a statutory analysis. In other than there's different chapters of the same of the same title. Just because they're different chapters, I mean, they're expressing a concern that in reference to the use of a firearm, both possessing it and using it, why should there be a different definition of what constitutes a firearm?
Well, I guess the answer is, why are there two different definitions in the first place? Why did the legislature bother to find it one way in Title IX and one way in Title 10? Again, could have just said on Chapter 1, wherever we mention firearms anywhere in this code means this.
But
Didn't do it.
But when I step back and I'm trying to understand just the raw distinction that you're trying to make, to me, the statute, the chapters were aimed to address the threat and intimidation and risks associated with firearms. And it exists regardless of whether the weapon can actually discharge ammunition. And so to me, that's the concern that the legislature had when it was drafting the statutes in reference to possession and the use of a firearm. And whether it's operable or not, the risk is still there when a weapon that is designed and is capable of discharging, as the Chief Justice read the definition, is capable of discharging explosion. That's the concern that the legislature was expressing.
Well, firearms are always dangerous, no question about that. But again,
But it would seem too easy for someone to not be in possession of a firearm without a firearm identification license, or to have an unregistered firearm if they simply, for example, took out the part of the firearm that holds the bullets and puts it off on the side. So it's not capable at that moment of firing anything.
Well, if it's simply not loaded, that's, I agree. If it would still,
But it would fit within your definition of it's not capable of being discharged. Or if they remove the mainspring and put it to the side and say, oh, I'm not in possession of a firearm that's unregistered, or even though I don't have a firearm ID, I can have this because it doesn't have a mainspring. It doesn't have any bullets. It's not capable of being fired. It doesn't seem like that's what the legislature was after.
well, again, it's just, I just don't see that the average person that might use a firearm in such a manner would think that far ahead.
Yeah. Criminals pretty smart sometimes.
So
Yeah.
well,
Most of the ones that I've dealt with haven't been so smart.
well,
Yeah.
the Chief Justice was expressing his thoughts. I mean, the hypothetical of someone going into a store with a firearm that has the firing pin in, robs the store and then steps out and takes out the firing pin. So um, he can't be charged with possession when he's outside without the firing pin, but can do so when he's inside the store with the firing pin.
Well, the issue is basically whether the thing can be repaired. I mean, it's, again, whether it can be repaired or not. And if you can stick a firing pin in it, that was, again, how the guns are designed. They obviously had to have a firing pin, fine. But first of all, if it had a firing pin in it when he did the robbery, that's where the offense happens, when he walks in, give me your money, and that gun had a firing pin in it. It's not going to change. It's kind of like you shoplift and you get caught going on the door and say, okay, I'll put it back. No problem, no foul. Same thing. You walk in with a gun that is capable of discharging a bullet. And that's where the crime begins and ends. And what you do with the gun a minute later, neither here nor there.
What if it misfires? What if the gun with a firing pin misfires and it doesn't engage? It doesn't shoot a projectile. Does that mean that he's not in possession of a weapon?
No, I mean, but by misfire, I mean it goes bang, but nothing comes out of the barrel.
But misfires, it clicks, it malfunctions. I don't know, I'm not a weapons expert, but it malfunctions.
Yeah.
So he's not in possession of a weapon.
Well, like as I said before, I think there's lots of evidence to prove how it works, and maybe it didn't work very well. But as I say, just if the gun is fired, that clearly proves that the thing can discharge a bullet.
Well, isn't that the point then? That the fact that it was capable of discharging, whether it malfunctions or not, doesn't determine
Well, that's
possession.
because the ammunition was faulty or whatever, but that doesn't mean the gun,
But
Okay.
under your approach, if there was no test beforehand, and at that moment it was not capable of firing a projectile, then under your analysis, he's not in possession of a firearm.
Well, the argument might be made, but again, when it comes to armed robbery, you can just get them on anything that looks like a gun. You're not really giving anything away to the guy.
I appreciate your thoughts, Mr. Timlin.
Thank you, Your Honors.
Thank you. All right, the court will take the matter under advisement. We'll issue a written opinion and will now stand adjourned.
All right.